But don't contest these results when the court has tried to move your case further along. Unless I put you under oath and you testify that you are an expert, a scientific medical expert of some sort on drug tests, you are legally positive for cocaine today.
Welcome to family court chaos, where paternity is settled, drug testing explodes, and parents gamble credibility for their children. Agreements seem close, but reality hits fast. Stay sharp for every twist, judicial warning, and consequence ahead. Subscribe, like, and share for non-stop courtroom drama breakdowns starting now today right here, folks.
Catherine Garcia is present and participating by video conference on behalf of the Attorney General's office. Welcome to all. Mr. Ferreira, what is the announcement?
Your Honor, we're very close to reaching an agreement. There is only two issues pending, which was a paternity test that the OAG has confirmed. And we are only pending, I guess, the confirmation of the parties to undergo drug testing. If we're able to get a reset just to finalize or just to get that drug follicle testing and announce an agreement to the court thereafter.
Ms. Garcia?
Your Honor, we do have the DNA tests ready and available, and we are not opposed to a short reset.
Mr. Leyva, what would you like the court to know in response to what Mr. Ferreira has asked the court? Speak into the microphone, please.
What would I like to know the court? Can you please repeat yourself, Your Honor?
So this is your opportunity to say anything you would like in response to what Mr. Ferreira has told the court, or with regard to anything else. Anything with regard to the purpose of your hearing today. Is there anything you want me to know?
Well, Mr. Ferreira stated that we have almost to reach an agreement. Okay.
Well, let me ask you this. Number one, the court heard that there was a paternity test. Ms. Garcia, the results of that test are available?
Yes, Your Honor, there are two children for the court, and the DNA results are available for both children. DNA was done through the AG's office before the suit was filed.
Ms. Garcia, do you know if that information has been filed or uploaded to the court?
Your Honor, I do not believe we filed the DNA results. We initially filed this proceeding, and it is now pending in master court, and it's set for hearing on December 5th. Then I believe Mom filed her counter petition with a writ of attachment, and it got set here. So everything should be heard together. But at this time, we have not filed the DNA results with the court.
But you have the results available.
That's correct.
Can you tell the court what the results are?
Yes, Your Honor, for both tests for both children, the results are 99.99% probability that I believe it's Mr. Castillo is the father of these children.
Mr. Leyva, the respondent?
I'm sorry, Leyva.
All right. Mr. Leyva, so they've not been introduced, they've not been admitted, but you've now heard what the results are. Do you have any reason to dispute those results?
No, I do not. I would just like my my paperwork in black and white of the results.
Okay, but you have no. You can have those, and I'm sure that the Attorney General's office can provide those to you. But I just need to know so that I know how we're going to proceed today. Whether you object to the court presuming that those are the results and that those results are accurate. So you have no reason to dispute those results.
I don't have no reason to dispute the results, as I repeat myself. I would just like them in black and white, because, we're humans and we can all make mistakes onto reading results. So right now, as Ms. Garcia said to Mr. Castillo's, I'm not Mr. Castillo, I'm Mr. Leyva, so I just want to know if the results are just the correct ones.
All right.
I apologize about that.
Okay. The second thing, Mr. Leyva, that Mr. Ferreira has told the court is that there's some pending drug test. Do you have any objection to any drug test for you or for Ms. Chagoya?
No, I do not.
Ms. Chagoya, speaking to the record, and by the way, nobody's under oath, so I'm just trying to help you both out to get to a good place with your children. Ms. Chagoya, do you have any objections to being tested yourself?
No.
All right, so let me do this. Let me see who here is available, if anyone from our DWI court. Mr. Cordova, Ms. Ramos, are you available? Can you see if Ms. Ramos and or Mr. Cordova are available? Actually, I would need both. Thank you.
Yes, Judge, we're available if you just want to give us a second.
Sure. All right. So, Ms. Chagoya, Mr. Leyva, the court is going to do what it does in every single case. This court has a policy that when there is a request for drug testing, it was my experience as a lawyer that when I used to make the request, you'd send in the request, you would wait at least 3 days, sometimes a week or 2 or 3 or more to get a hearing, and then you would wait for the hearing. Sometimes in this court, you would get a result, sometimes you wouldn't. And then you would go out and get drug tested 3, 4, 5 weeks later. What are those results then? So if there is no objection, I'm going to order that both of you be tested internally here through our DWI court. The results will be available immediately. That is going to cut down the time that you wait on your case by 3, 4, 5, 6 weeks or more. You'll have the results right now. And in this court, once a request is made, I never test one person. And sometimes that doesn't always work the way people think it does, because sometimes the person that's making the request comes out positive and the person whose test was requested comes back negative. So you never know, right? But I want to treat all persons the same. So be patient. A female will test you, Ms. Chagoya. A male will test you, Mr. Leyva. You'll have the results. We'll read the results on the record. We'll put the results on the record, and that'll help you get to a better decision. You'll know that you have nothing to worry about, or that the court does have some reason to be concerned. Do you have any questions for the court, Ms. Chagoya?
No.
Do you have any questions for the court, Mr. Leyva?
Yeah, the only thing, whenever I do get tested, I still need time to go over on what Mr. Ferreira had advised me on doing to coming on to an agreement.
Right. But so the reason this is, I think, a good idea for in the best interest of your children is that gives you more information, right? So once you start communicating and talking to Mr. Ferreira, you can say, look, my test is negative and hers is positive, or vice versa, whatever you want, whatever the results are. But at least that puts you both in a better position to know that there's nothing to worry about. All right. So be patient. We'll have some folks come in and you'll be tested momentarily. Do you have any other questions?
No, I should be.
All right. Stand by.
Thank you.
Ms. Chagoya, Mr. Leyva, please step forward. All right. Ms. Chagoya, the court called this case at 10:47. It is now 12:15. Mr. Leyva and Ms. Chagoya, when we last left off, the court was asked about a drug test. The court asked each of you if you had any objection to the court ordering it. Neither one of you said no. In fact, you said you agreed. That instant exam, I believe, has already been performed. Let me ask our DWI court case manager to step in front of a microphone and tell the court your name, please.
My name is Lizette Ramos, and I'm one of the case managers for the DWI court program.
Thank you, Ms. Ramos. Ms. Ramos, did you have an opportunity to administer an instant drug test to Samantha Chagoya?
Yes.
And was a drug test, an instant drug test performed on or for Mr. Jorge Leyva Jr.?
Yes.
Are the results of those tests ready?
Yes.
Would you hand those results to the court, please? All right. Ms. Ramos, would you tell the court the results of the test for Ms. Chagoya?
She came out positive for marijuana.
All right. And would you tell the court the results for the test for Mr. Leiva?
He came out positive for cocaine.
All right. Mr. Ferreira, any questions for Ms. Ramos?
No, Your Honor.
Mr. Leiva, do you have any questions for me?
Yes, I do.
What's your question?
I saw my drug test and, it's not the first time that I come out, negative for drugs. Those drug tests that I got screened by, if two lines are available, even though if one line shows a little bit, light slower than the other one, that still means a negative. And I saw my drug test right now, all my two lines, I saw the one of COC.
I highly suggest you stop talking, because my question was if you had any questions, and you're questioning the results of your drug test. You're positive for cocaine. I don't think that's very good. It doesn't speak very good of you, but I also think that and I told you all what was about to happen. I said, don't think that this is going to go how you think it's going to go, because sometimes when people ask for a test, they come from positive themselves, which is exactly what's happened here. The thing is, you tested something for much harder and much worse. So if you want to dispute the results of this test, I suggest that today you go and get a test with another third party, whether it's LabCorp or some other thing, and you come back to court and you tell the court, look, I know that I tested positive here on October 28th with an instant test for cocaine, but on that same day or the very next day, I had a blood test. I did a hair follicle test. I did this free of charge to both, trying to save you time, trying to save you money. But don't contest these results when the court has tried to move your case further along. Unless I put you under oath and you testify that you are an expert, a scientific medical expert of some sort on drug tests, you are legally positive for cocaine today. Don't dispute this at this point. You're going to do yourself a disservice, both of you. Ms. Ramos, thank you for your service. You're excused. It's good to see you. All right. I'm going to ask you one more time. Do you have any questions? Questions?
The instant test detonates negotiations. Dad challenges cocaine results, but the judge draws a hard line. You're legally positive today. Science beats argument, excuses backfire, and leverage evaporates. This ruling reshapes custody risk immediately. If you were advising him, would you contest harder evidence or regroup strategically now instead today?
So if I go right now and I do another drug test or screening somewhere else, and I bring it and it comes out negative, then there was an error here in the courtroom with the drug test.
I don't believe there was any error. What that means, and this is not the way the legal system works. What it would show is that you would now have controverting evidence. You have a positive test for cocaine. It's never going to go away. But you can have this other test that says you can call the other one into dispute and say, look at the results of this test. But I can only suggest that you do that, right? If you think that you haven't consumed any illegal substances in the last 30 days, that might be a good idea. And that would give the court some other information about how best to make decisions for each of you and your child or children. Yeah. So if you want to go get another test, go get another test from a reputable scientific testing facility and come back and show the court, make a copy, file the original with the clerk, make a copy, send a copy to Mr. Ferreira, and he might want to do the same thing for his client. Maybe they want to dispute the results of that too, but right now, both of you are positive. No, nobody's looking good here right now.
Yeah, then I don't have no questions, Your Honor, and I'm good.
All right, Mr. Ferreira, we're here on this ex parte and order for issuance of writ of attachment. What is your client's position at this point?
At this point, Your Honor, we do want more time. The fastest reset we can possibly get to get those test results, drug screenings, and at this time, ask the court to extend the temporary restraining order for up until the next setting.
What is it, remind the court, what is it in those temporary orders that causes a change? Or what is specifically, what is your request?
Still to prohibit contact between parent, Mr. Leyva, and the children, and not to remove them under the possession of Ms. Chagoya. That's the only two concerns that we can.
Let me ask you this, how many children before the court?
To Your Honor,
Ages?
9 months and 2 years.
And how long has Ms. Chagoya been in possession of those children? Yes, when you got them back.
It was last Monday, so a little bit over a week.
For a week. Mr. Leyva, the request is, so let me give you a reset date to give you both a better idea of what your position should be. I'm going to reschedule this for a week, November the 4th at 2 p.m., which puts up an additional burden, and it's a good one, on each of you, that if you want to dispute these, I suggest you drop what you're doing and head over to a facility so that the results might be ready. The request, Mr. Leyva, from Ms. Chagoya through her lawyer is that the court leave everything in place until you come back on November the 4th at 2. Do you have any response or objection to that?
You know, in case if I respond to a matter that I'm not supposed to, I apologize. You know, I am representing myself.
Sure.
Second of all, if I have any response, the only thing is just as long as my kids are well taken care of, you know, due to the fact when I returned my kids were not sick of anything. Right now, my little boy, he's really, really sick on the outside. He's coughing, mucus and all kinds of stuff. It just burdens me in any type of way. I understand that Ms. Chagoya has to work, right? She works at a certain time. I'm not sure who my children stay with. Me, myself, and I have my own business. I honestly go to work if I don't need to, if I have to. My kids are with me 24/7. And since the fact, whenever I had them for the past 4 months, which CPS was involved, and CPS did me various drug tests, and all my drug tests came back negative. So that's my only response, as long as they're in good hands, and you know.
So there was a CPS case, and you were tested for drugs and alcohol?
Yes.
When did that test happen?
If I may recall, it's been probably about 40 days ago.
All right. So look, I've made some suggestions. I can't tell you what to do. I can't tell you how to run your case, but I can make suggestion based on what I believe would give the court the best information to make decisions on your 9-month-old and your 2-year-old. So if you have the results of those tests, why don't, and you want to get, you know, file them with the court, and you want to, both of you can each now go out and get some other tests done and see what differences there are, if any. That might give the court some really good information about what's really going on.
Okay.
So I suggest that you do that. We'll come back on November the 4th. Before I release you, so I'm going to extend those orders. Oh, I was going to ask you, Mr. Ferreira, what is your understanding about the parties' ability to communicate?
I think they're doing an excellent job. It started off a little bit, I guess, hestant, but
Sure.
it's much better now. I think they can co-parent effectively. It's just the speed bump we have to get over.
All right. So continue to remain in contact. And under the terms of the orders, Mr. Ferreira, does Mr. Leyva have any electronic access to his children?
I don't think they're specifically listed. But we can work with Mr. Leyva to have that.
So the interesting thing about your case, Mr. Leyva, is that your children are not 9 months and 2 months. They're not really old enough to communicate. So normally when children are over the age of 3, I can do electronic communication. Ms. Chagoya, give the court a time that you can provide video conference or um, uh, video access to Mr. Leiva's children, what's the best time to do that? The time that they're most likely to be awake and responsive.
Well, honestly, it would really base off when I go to work. Sometimes I go in the morning, sometimes I go in the afternoon, so it would really go
It's
based on
not
it.
based on when you go to work. It's
till they
based,
go to daycare.
right? So then have the daycare person
Okay, then
give
that sounds
access.
good.
My
That's
question
fine.
is it 8 a.m.,
Um,
noon, 6
we can do
p.m., 8 p.m.? I don't know your children.
Uh-huh.
I don't know their schedules. I don't know when they go to sleep. I don't know when they're most active.
Okay.
You probably know that. So you give me a time and I'll give access to Mr. Leiva once a day. And it can be you or whoever you give possession of your children to.
Okay.
I'm not fishing for a certain time. I'm not telling you, tell me noon or tell me 8 p.m.
Ah.
Just give me a time.
Noon sounds good. Yeah.
Noon. All right. So between noon and 12:30, anytime in that window, you can have video conference time with your children. I'm not going to say it should be 5 minutes or 20 minutes. I think anything between 2 and 5 minutes is reasonable because they're small. You're not going to have a conversation with them. You're just going to see them, know that they're well, they're taken care of. If you see anything that concerns you, let me know on November the 4th.
Here comes the brutal comparison. Lice versus cocaine. The judge strips emotion away and centers safety, admitting no good options exist. Until clean tests appear, status quo stays. It's a devastating reality check. Allegations collapse under chemistry, and parenting arguments lose power when substances enter the equation publicly in open court.
Okay.
If I may speak, Your Honor.
Sure.
Right now when Ms. Chagoya mentioned daycare, honestly, this whole whereabouts, the reason why I got my children from Ms. Chagoya was because whenever she took them to daycare, my children were full of lice. They had lice in their head, and I have screenshots where Ms. Chagoya is telling me, you know what, they probably got it from daycare. Honestly, to me, daycare, my kids, I really don't want them in daycare. Now, if it's possible for the court to take into consideration that in case Ms. Chagoya has to work certain hours a day, me, myself, and I and my spouse were willing to take care of my kids during that workable time of Ms. Chagoya. Does not matter whether it's noon, afternoon.
So here are my options. You're asking me to make a decision, and I don't think it's a bad one, but here are my options. I'm going to assume that what you're telling the court is true. You're not under oath, so this isn't really testimony, but you shouldn't lie to the court. And I'm going to presume that you're being honest with the court. My options are to leave the children in Miss Leiva's possession, and when she works, they would go to daycare. And let's assume that you're right. The daycare is full of lice. Or to give them to you, and you're using cocaine. What do you think I should do? My options are lice or cocaine. What would you do if you were me? I know they're not going to die of lice. I know there's medical solutions for it. I can't control people's behavior while they're under the influence of illegal substances. In other words, I'm basically trying to get you to understand that I don't have a choice. I think legally and factually, the only choice I have is to keep things as is until you both can come back and tell the court, here is a negative drug test. I don't mind you contesting the results. I know how it sounds, but you all got to be good examples for your children. All right. So I'm telling you, it's going to stay as is until you come back and say, here's a negative test. I want visits. And I'm going to turn around and say, you got it.
Sounds good.
All right. Anything else on this case, Mr. Ferreira?
No, Your Honor.
Ms. Chagoya, Mr. Leiva, I wish you both very well. More importantly, I wish your 9-month-old and 2-year-old all the best. Mr. Leiva, what is your email address?
@gmail.com.
Did you get that, Ms. Flores?
Yes, Your Honor. Also, the setting for November the 4th, would that be an in-person setting, Your Honor?
I need you both here in person. Of course. All right. I wish you all the best. Good luck.
I would just need to know what time the court.
2 p.m.
Thank you, Judge.
Maybe excuse me.
Have a good day.
Thank you. filed an agreed motion for.
I just want to make sure that the microphone is on.
Yes, Your Honor. We filed an agreed motion for continuance yesterday. Basically, we're asking just to move the next court date to the final hearing, which is November 20th, I believe.
To move this hearing then, or to just hold that hearing?
Just to hold that hearing.
All right, as a final hearing?
Yes, sir.
Well taken.
And Your Honor, on this case, if I may ask a quick question.
Sure.
Your Honor, my notes show that there were temporary orders that were granted back in April with the conservatorship, visitation, child support, medical support, but as yet, no temporary orders have been submitted. And so I was just going to follow up on that if those temporary orders were going to be submitted.
Mr. Castillo?
Yes, Your Honor. So that agreement was made before I was hired. But there have been no issues, Your Honor. As of in the interim with possession rights or any child support issues. So that's why we agreed just to move it on to the final hearing.
Well, it sounds reasonable to me, but to Ms. Garcia's point, if there's any changes or modifications, make sure you incorporate those into the final orders, because if no temporary orders are filed, the AG's office is going to have this lingering question: what happens from the date of those temporary orders to the final hearing? So you need to just, in other words, make sure you have all of that time period covered and don't leave a gap, because that could leave one of the parties in a different situation that they think they're in.
Understood.
All right. So I'll call this case on November the 20th at 9 a.m. Well taken. Any other cases for Mr. Castillo?
That is all.
It's good to see you, Counselor.
Thank you,
The
Have a
case
great day.
closes with temporary orders extended, contact limited, and a clear path forward. Test clean, then return. The judge prioritizes children over pride, delay, or debate. Consequences linger for both parents. Like, comment, and subscribe for more real courtroom stories where truth meets accountability every day in real life.